Tēnā koutou, tēnā koutou, tēnā koutou katoa. Welcome to the University of Waikato. Welcome from Te Parenga Faculty of Law, and especially welcome to the 2015 Harkness Henry Lecture. Welcome members of the judiciary, practitioners, members of the community, staff and students of Te Whare Wānanga or Waikato. For those who don't know me, my name is Wayne Rumbles. I am the Dean of Law at Te Parenga, well, at least for the last 4 months. As new Dean, I am keen to strengthen our ties with the profession, and I see events like this as key points of interaction. We stand at a very exciting moment for the faculty. You may have seen at the top of the campus a crane or two. These are on the building site of the new law faculty building located in the Law and Management Precinct. Next year we'll move from our quarter-of-a-century home in prefabs to the purpose-built building equipped with student lounges, computing facilities, meeting and seminar rooms, and a fully equipped moot court, which with the internal fittings from one of the Manukau district courts. I tried to get them to keep some of the graffiti, but I think it's going to be sanded off. And next year we'll be able to host at least the pre-lecture refreshments within that facility. We have had a long association with Harkness Henry, this being our 24th annual lecture. I recall attending these lectures when I was studying at this faculty in the early 1990s as a mature student. Meeting Warren Scotter, partner at Harkness Henry, and it was with great pleasure that Te Parenga and the university presented him with an honorary doctorate last year in recognition of his contributions to the legal profession and the faculty of law. Harkness Henry not only supports the faculty through this lecture, but also has employed a significant number of our brightest graduates. This year, for the 24th Harkness Henry lecture, we are lucky to have Judge Neil MacLean. Judge MacLean grew up and was educated and began his practice in law in 1968 in Christchurch and continued in practice until he was appointed to the District Court bench in 1993. During this time, he served as the Christchurch Coroner from 1978 until his appointment to the bench. He was sole resident judge in Gisborne for 6 years and then transferred to Hamilton. During this time, he continued his involvement in complex inquest matters. Judge Neil MacLean was appointed New Zealand's first Chief Coroner under the Coroners Act in 2006, and he took up that position in 2007 until his retirement in February this year. He was president of the Asia Pacific Coroners Society in 2010, and he was honoured by the University of Canterbury in 2012 with his an honorary doctorate of law. Judge MacLean now sits on ACC appeals to the District Court. He's married to Susan, who is here, and his 3 adult children and 5 grandchildren. In 2000, the Law Commission published its report on the Coronial system, and tonight, Judge MacLean will reflect on his experience within that unique system, drawing on its long history and recent reforms in sister jurisdictions. Judge MacLean is ideally positioned to give us his personal insights on the realisation of the Law Commission's recommendations from that 2000 report and where the Coronial Court may be going. Without further ado, I ask Judge Neil MacLean to present his lecture, The Vision and the Reality.
Thank you. No disrespect intended by sitting. I have some back issues, probably as a result of many years in the judiciary sitting down. So I hope the line of sight is okay. The subtitle of my lecture tonight is Reflections on the Evolving Role of the New Zealand Coroner in 2015. It's particularly good to see Margaret Wilson here tonight because I know she had a very significant role to play when the reforms were introduced all those years ago. On Black Friday, 13 February this year, I retired from what I think was the most interesting and challenging role I've ever had in my life. when I stepped down as Chief Coroner. Although in theory, along with the other judges here tonight, I am still ex officio a coroner, I anticipate it's unlikely that I will do any more coronial work. This lecture affords me an opportunity to reflect on over a third of a century as a coroner, initially as a deputy coroner in Christchurch, then the regional coroner, then my appointment as a judge, as you've heard, 14 years ex officio, and then the 8 years as a chief coroner. I'd thought when I went to Gisborne that would be the end of my coronial days, but somewhat surprisingly and to my pleasure, I became involved in a number of interesting inquests over the next 12 or so years, primarily because I had got to know a lot of the 70-odd coroners around the country. And when the 1988 Act was introduced, there was a need to produce a manual for the first time for coroners. So I got to meet a lot of those 70 coroners. They then, when faced with conflict of interest situations, would often approach me to see whether I could handle the inquest for them. And with the permission of the Chief Judge, I was very happy to do that. Occasionally a matter had gone off the rails somewhat and gone on judicial review to the High Court, and the judge might well direct that there be another inquest, but preferably handled by a district court judge. So I did a bit of that too. It was a fascinating experience because it really brought home to me the difference between operating as a judicial officer in an adversarial environment as opposed to an inquisitorial one. There was a sense of freedom, of liberation, but also increased responsibility. Because as a coroner, I had to make decisions as to the scope of the inquest, when it would be, who the witnesses were, and what evidence there would be. Sharp contrast with the sort of jack-in-the-box role of a judge in an adversarial jurisdiction who turns up, hears what the parties have to say, and gives them an answer. The parties define the issue, whereas in a coronial jurisdiction, the coroner does. I'd followed the reform process closely and had been asked for advice on one or two occasions. When the opportunity came to put my hat in the ring for the job as Chief Coroner, I applied and to my surprise was appointed. I think the appointment came somewhat out of left field as far as some of the coroners were concerned, because a number of them had also applied for the job. So it was a tense, interesting time. In effect, all the 70-odd existing coroners were sacked. And if they were interested in continuing as coroners, they needed to reapply. Changing from a predominantly police-driven, very localised and inconsistent process to a coordinated, civilianised one was a demanding, frustrating exercise. When I first hit Wellington anonymously, because there was some delay in announcing it, and saw the huge pile of policy documents and what had to be done, I almost turned and ran back to Hamilton. But I decided I'd give it a go, put my head down and went. And somehow we got there to get the system up and running on 1 July 2007. So then had 8 years as Chief Coroner, basically with the bare bones of the legislation, very little guidance as to how I was to do the job, what was involved. There was the Act, of course, but at all stages there was another document, which I'll talk about in a moment, which I regarded as my Bible, or perhaps the New Testament as opposed to the Old Testament. I'll reflect on my experience as a Chief Coroner, but also my perspective now looking back, and to some extent forward, on what's happening here compared with other jurisdictions, where we came from, why we are where we are now, and, as I say, have a tentative look forward. In the journal version of this lecture, there'll be quite a bit more about this next bit I'm going to talk about. So if you read the journal article, you'll find there's some stuff in there that I'm not going to talk about tonight. This year, there's been quite a lot of hoopla about the 800 years since Magna Carta. So there's been a lot of discussion about the extent to which our present legal system, our parliamentary democracy, links back to Magna Carta. Clearly, it was a significant foundation document. And as Lady Justice Arden, a member of the Court of Appeal of England and Wales and a former Law Commission head there, and ad hoc judge of the European Court of Human Rights, observed in a recent article, Magna Carta is a monumental affirmation of the rule of law. It proceeds on the all-important assumption that disputes are to be decided in accordance with law, and that the law was not what the king said it was, but what the judges said it was, what the common law of England was. We look back 800 years and we wonder sometimes about the durability of some of those concepts, and yet there is another aspect of our current legal system that can trace its roots back before Magna Carta, and that's the coronial jurisdiction. One of the standard texts about coronial work is called Jarvis on coroners, and I have a copy of the second edition, facsimile, and also the latest, the 16th edition, which came out last year. Jarvis, in the second edition, observed, quote, in a consequence of the rust and relaxation inseparable from ancient institutions or the efficiencies of its officers, has fallen from its pristine dignity into the hands of those who are in some instances incompetent to the discharge of their present limited jurisdiction. That was what he thought of the coroners. Telling it like it is, isn't it? Criticism of coroners is nothing new. As you probably know, the word coroner comes from the Latin corona, and the coroner's role in England was initially effectively as a kind of tax gatherer, informant for the king. The origins of coroner probably go back to the time of Alfred the Great, and Jarvis comments on this. Whatever the history, in the latest edition of Jarvis, Dr. Paul Matthews, senior coroner for the City of London, which sounds impressive, but of course it's only the square mile, and not many people die in the square mile. But when they do, it's interesting. As he put it in the latest edition, the office of coroner is a very ancient one, but no one is quite sure of its origins. There's some evidence that it existed before 1194, but it's only because of Article 20 of the Articles of Eyre that the office can now be conclusively established. The Articles of Eyre had this wording, quote, in every county of the king's realm should be elected 3 knights and 1 clerk to keep the pleas of the crown. Now, keeping the pleas of the crown, he seemed to be looking after criminal law matters, those interests where the crown had an interest. Magna Carta has a little aside about coroners. Article 17 says, no sheriff, constable, coroner, or other of our bailiffs shall hold pleas of the crown. In other words, the concern was that coroners were getting too big for their boots, even in those days, and they were dealing in areas involving crime and punishment where they really didn't have the authority. In time, the medieval coroner became primarily focused on sudden death. Why? Because it was a potent source of revenue for the crown. That was because the focus of the justice system then was all about compensation for the victim or the raising of revenue for the crown. And as you may know, if a person was killed, suffered a violent or unnatural death, there was an investigation which was carried out by the coroner to see whether or not the deceased person was a Norman. Didn't matter if they were anything else, but if they're a Norman, then a fine called the murdrum was imposed on the community. So there was a real vested interest in the community in making very sure that the coroner got the right answer. Otherwise, they're all lumbered with a collective community tax. The coroner's job, after the hue and cry had been raised, was to go to the body and assemble a jury, basically anyone he could find in the pub, and if the body was Saxon, unless it was proven the body was Saxon, it would be presumed to be Norman. The coroner had some other interesting roles, including presiding over trial by ordeal. That's the old thing where you pick up a red-hot poker and if you don't get burnt, then you're innocent, on the basis that God will protect the innocent. But gradually the coroner's role evolved into the more modern medico-legal witness, preserving the record until the King's justices got around to dealing with it on their travels around the country. The coroner would take sureties, sort of bail bond. And that was another good source of revenue because, not surprisingly, witnesses, once they got wind the King's men were coming, would scarper and the fine bail bond would be forfeited. So by 1500, the sole remaining function of a coroner was that of holding inquests into deaths. And those of you who are familiar with Hamlet will recall the discussion about the Crowner, as he was then called, as to whether Ophelia had committed suicide. The point generally there was that if it was a suicide, the estate was forfeit to the Crown, so the monetary interest as well. And there are other nasty consequences, such as being buried at the crossroads with a stake through your heart. Apparently that was to confuse the spirits leaving the body as to which direction to go in. So the role evolved over the 18th and 19th century and more moved from protecting the financial interests of the state or the king to an interest in the medical cause of death. In New Zealand, the office came across at a very early stage, at least as early as 1846, and the law came across, as did so much of our law, from England. We know that New Zealand's first coroner was a doctor, Dr. John Johnson, who took up office in May 1841. The records of early inquests held in Auckland identify concerns still topical today, including alcohol abuse, drownings, deaths in custody, and work safety issues. The coroner always had the useful opt-out, which it would be lovely to still have now, where it was a bit obscure, cause of death, quote, visitation by God, unquote. So any fit person could be a coroner. They had jurisdiction over fire, which some of our Australian colleagues still have. And they also were responsible for particularly checking out deaths of violent deaths or persons in, quote, lunatic asylums, and if any fire occurred, destroying crops or merchandise. They held inquest with a jury, but they were also authorised to ask any medical practitioner, didn't have pathologists in those days, to carry out a post-mortem examination. There's a fascinating book written by Gluckman, who is the father of the present Prime Minister's scientific advisor, called Touching on Death. And it's got the records of many of those early inquests. The jury was often quite outspoken in terms of adverse comment, like in one case, the suicide of a man was likely to be related to the promiscuous behaviour of his wife. Don't think you get away with that now. So the Coroners Act gradually evolved through several consolidations and until 1951 Act, which was really a consolidation act as well. And that was the act, and this really dates me, in which my appointment was made. My warrant is signed by Governor-General Keith Jacker Holyoake. The intention of that legislation was to take the jurisdiction away from a common law jurisdiction and put it in statutes. The jurisdictions as to fire was taken away, and in time the requirement to sit with a jury evolved. We then come to the 2006 Act, but before that I want to just talk about the Law Commission, which came out in 1999 with a report. It's interesting to see who the Law Commission was. It was David Baragwanath, Judge, Paul Heath QC, now a Judge, Judge Margaret Lee, the late D.F. Dugdale, Denise Hennerak, ONZM, who of course is one of my colleagues on the District Court bench working on ACC appeals, and Timothy Brewer, ED, now also a High Court judge. They put out a seminal discussion paper. It arose partly, I think, because they had done an earlier investigation about succession law, and in the course of that, they became aware of aspects of coronial practice that were of particular concern to Maori and others, particularly in respect of cultural, religious or personal injuries. And in the preliminary discussion paper, number 36, there was a significant focus on issues around body and body parts and post-mortem procedures, and comment on the failure of government departments to act on recommendations. They observed a lack of uniformity of practice, no systematic appraisal of reports to enable patterns to be established, no training, and the need for a chief coroner. Trouble with availability of coroners after hours, and trouble with getting communication of recommendations with a feedback mechanism, and they envisaged an annual report by the Chief Coroner. Now that never came into legislation, and this is actually my first report today. That report was the Bible that I referred to earlier. It noted the system was patchy, unsystematic and inadequate, also haphazard. They put out some key recommendations, and I won't cover them all, but some of the key ones were coroners must be legally qualified, proper statutory appointment process, training, consolidation of coronial districts, keeping the existing Justice of the Peace function as a backup auxiliary, the annual report I talked about, clearing up some areas about who controlled the procedure, who had legal control of a body at various stages, making it clear that there must be better communication with families, ability for a chief coroner to monitor, oversee and control the process, development of guidelines, complaints to be determined by a chief coroner. Specifically, some of the chief coroner's roles, and again I won't mention them, were education of the public concerning coronial matters, acting as a liaison and contact point, making sure coroners' reports were publicly available, handling complaints, preparing plans for major disaster, issuing guidelines, discussing issues regarding sudden infant death, being involved in mortuary and needs regarding mortuary facilities. Now, not all of those things came to pass, but it's interesting just to see what they had in mind. One of the significant things, and something I've always sort of taken to heart, is this comment that they made, quote, "Protecting the lives of its citizens, a country's citizens, is the primary function of the state. Its processes for investigating sudden death ideally should be geared to finding the causes and eliminating for the future, while respecting the sensibilities of the family." It's the old concept that Jarvis mentions of John Donne. You remember? "Never send to know for whom the bell tolls, it tolls for thee," i.e. the death of any member of a society is a significant event with ramifications for the rest of us. And I think the events over the last few days, that little boy on Bodrum Beach, really bear testimony to the strength of that observation. So what did Parliament do? Well, perusal of Hansard shows that when the bill came to Parliament and went through the select committee stage, there was largely bipartisan support, and it did pick up on a lot of the recommendations. In some respects, it actually rather boldly went beyond what was recommended. For a start, moving to full-time legally qualified coroners, and not having a continuity of the Justice of the Peace role. And the proposal I mentioned before that all the existing coroners would be sacked. Not surprisingly, that provision caused a considerable degree of angst amongst coroners, with rumbling discontent, talk of compensation for loss of office, unconstitutionality, but I must admit, and as I found in some, a great sense of relief. It had been a bit of a burden, a rather thankless task, not very well rewarded. My English and Welsh colleagues, coroner colleagues, look in awe at what the New Zealand Parliament did. They talk about it being the big bang approach to coronial reform, as contrasted with what they'd done in England, which we'll discuss later. So I took office, hit the ground running, and several things I had to do. One was, by 1 July, have all the coroners selected, sworn in, trained and ready to go. Getting a bench book organised, because there'd never been a bench book, getting forms underway, meeting with interest groups up and down the country, and generally repositioning the whole structure from a haphazard, locally focused one to a consistent national framework. One of the most challenging but eye-opening experiences for me was travelling around the country meeting representatives of iwi. While the Commissioner had anticipated the appointment of a kai whakahere, in fact that never happened, but as a practical lever I was aided immeasurably by the support of people such as Harris Shortland, the father of Brent Shortland, who many of you will know is a lawyer here in Hamilton before he became a coroner, and others from the ministry, and more latterly Nada Glavish of Auckland, who you may remember was the lady who answered the phone, kia ora, and all hell broke loose all those years ago. Nada's been a great person to work with, a real spade is a spade lady, but of immense help in building relationships. Many of the Maori groups were very suspicious, very uneasy, and I heard some harrowing tales involving lack of sensitivity and that the Pākehā system just didn't get it as far as tikanga was concerned. All I could do was to say, look, that's the past, I'll do my best to make sure those bad old days don't come back. But there was a strong feeling that, well, we've heard this all before, you'll just pay lip service to our concerns as you have in the past. So what were the concerns? Well, it was about things like long retention of body parts, no explanation, no recognition of the Maori way of doing things, the desire to have the body accompanied at all times, unease that there were unnecessary postmortems, exactly what was being done, and lack of information. There was also unease amongst the pathology profession who read the Act and thought, my God, this is if this is implemented, there's not going to be enough work for us to do. We'll lose the sort of critical mass of keeping up to date. Also, there was a groundswell going on, as I later became aware, that some forensic pathologists were strongly urging that we move away from a legally qualified coroner concept to a more American or medical examiner system, i.e. doctor-run, not lawyer-run. But, as I say, there was this main concern that the number of postmortems would drop so dramatically that it would become uneconomic and or detrimental to maintenance of certain levels of expertise. Those concerns turned out to be unwarranted, at least so far, and I will speak more about this later. Some of the particular areas I want to talk about and what the Commission thought and then what we did was unnecessary postmortems and delay, not recognition of tikanga. I did my best to ensure with training that all our coroners got access to the appropriate information. We arranged for them to go on marae visits. Many of them went on Maori immersion courses to kind of bring them up to speed. Because we had, of the 16 coroners, only 3 had Maori connections, including, of course, Gordon Martinga, who you know here, and coroner here, and Brent Shortland, who comes from here. So we worked on a bench book. We set up an intensive week-long first ever orientation program, as judges get. One of the slightly unsettling surprises was that I discovered that the Institute of Judicial Studies, which handles continuing legal education for judges, did not see coroners as part of their brief. And so, apart from being able to participate in immersion courses in Te Reo, we had to organise all our own training. But the major problem was this question of early decisions, removing uncertainty. So one of the major things we did was set up a whole new process in the form of a genuine 24/7 service. Initially, this was not supported by the ministry after hours, so that the coroners had to handle it from their homes, on the telephone, fax, computer, eventually. It was stressful. It was demanding. That's evolved over the years to the stage where we now have around the clock, fully Ministry of Justice staffed National Initial Information Office, called NIO, and that is the sole entry point for any reports, questions or issues arising immediately after a death, which might be part of the process. There wasn't wholehearted approval of this. In fact, there was considerable angst, even amongst coronial ranks, because it wasn't easy, it was quite hard. Other stakeholders, including police, pathologists and funeral directors, were also initially rather sceptical. I think most of those concerns have now been allayed, but it's going to continue to evolve, and that 24/7 NIO service is continuing to take on extra functions and change, and I think continuously improve. But the whole aim of it is to ensure, and I think it does now, that there is a genuinely accessible, receptive and proactive system in place to ensure no matter when and where a death occurs, the system is immediately on the front foot and able to make significant decisions without the sorts of delays that plagued the system in the past. One of the problems was, of course, that this threw up extra challenges for police and pathologists and funeral directors and other agencies, because in many cases, while we'd become 24/7, others, except police of course, were not 24/7. One of the unexpected spin-offs was that despite that initial police scepticism and the concerns of others, one of the end results was a huge but largely objectively unquantifiable reduction of a lot of time wasting and effort by police, chasing around trying to find doctors, and bringing cases into the system that didn't need to, but missing ones that should have. Some basic facts, just to amplify that. About 30,000 people a year die in New Zealand. Roughly a fifth, i.e. 6,000 of those, now come to the attention of NIO and the duty coroner. And there's one duty coroner on at any given time, taking all those first reports. In the past, if there's no doctor available or uncertainty about whether it could or might be certified, there could be considerable delays, particularly after hours, with frustrated funeral directors, doctors, and particularly upset relatives wondering what on earth was going on. As I say, many deaths needlessly came into the system, and some deaths that should have did not. So of that 6,000 that come to our attention, immediately about half are triaged out after discussion and a look at it by the coroner and his or her staff, and that often involves a direct coroner to doctor discussion. They can be interesting, lawyer talking to doctor. The reality is that many in our medical profession were, and I'm sure will continue for a long time to be, foreign trained, and they don't actually know really how our system works when their certification responsibility kicks in, etc. A lot of that we can now sort out very quickly. The other spin-off is that once it's been decided jurisdiction should be taken, we can move quickly then on to the post-mortem examination or discussion anyway. Now again, not all forensic pathologists particularly are happy about this and say that some wrong decisions are being made by lawyer coroners who don't understand the medical implications. I think it would be fair to say that the default situation used to be, with some exceptions, that the question of whether the matter came into the jurisdiction or not was largely done by the police, or it was simply put off. And there was a default assumption of a post-mortem examination. Why? Well, because we've always done a post-mortem examination. That's the way things are. In the past, again, with some exceptions, if whānau or family were upset and wanted to challenge the issue, it wasn't very easy. First of all, you had to know who the relevant coroner was. Remember, there were 70 of them. How to get hold of them and how to get your concerns through. By default, police personnel ended up trying to grapple with this, often with little training, in confrontational situations, particularly, say, in the case of the death of a baby, but also typically the case of an elderly person where the family would be saying things like, "Oh, come on, Mum was 93. What on earth do you want a post-mortem for? Isn't old age enough?" So the new process, once bedded in, meant that now the coroner at an early stage was involved. They were lawyers. They pragmatically dealt with the letter and the spirit of the legislation. And the thrust of that was that spiritual, ethnic, cultural and other concerns were a factor that must be weighed in the balance when making a decision. There were some monumental stand-up rows in the early stages, both between coroners and pathologists, coroners and some police, add to the mixture occasionally family directors, family members, etc. And Peter Ryan here tonight could probably, if you asked him afterwards, tell you a few stories of his own. I think most coroners could. Built into the Act, reflecting Australian experience, was the establishment of a fast-track appeal procedure if family or whānau were dissatisfied with the coroner post-mortem decision. And we expected, on the basis of the Australian experience, that would we be inundated with urgent appeals going to the High Court. And I went to Mr. Justice Randerson was the Chief High Court judge there, and I spent some time sitting down making sure that there was a cadre of judges there geared up, at short notice, literally on a Sunday if necessary, to deal with an urgent application. Do you know how many we've had since then? None. Why? I think it's partly because of the quality of the coroners that we selected, using those lawyer skills, but I think more importantly, pragmatic common sense coupled with an acute awareness of the importance of the role of next of kin. We, fortunately, do not have the legislative authority to get into resolving the body claiming type situation, which can happen from time to time. Maori, Pākehā, Maori, iwi. Some of the Australian states did. My stance will be, we haven't got the jurisdiction, let's stay out of that. And what we would do, if there was a stand-up row about who was going to have the body, we'd simply say, well, until you sort it out, the body stays where it is. And I think in a curious way that actually fitted in with the Maori way of doing things, which is, this is something the parties sort out between themselves. They don't want an imposed solution from a Pākehā system. They'll resolve it themselves, and they always do. I want to just talk a little bit about, from time to time, there is, as you probably know, a bill just come out from Select Committee, an amendment bill, doing essentially a bit of a tweak of the Coroners Act, tidying up a few areas. But I'm encouraged to see that the bill, as reported back now, does settle another simmering little dispute that was going on, that the coroner still retains overall legal control of the matter as to whether or not there'll be a post-mortem, and if there is, whether it'll be limited or full. But I just have a bit of an unease about how in practice, a little phrase that's in there, quote, the pathologist may otherwise carry out the post-mortem as he or she thinks fit, unquote. What that means, how that will pan out in practice. I'm glad I won't be around to be involved in those discussions. I've noted in my long career as a coroner, I think, a distinct shift in the general attitude towards body parts, retention and explanations. In the past, a bit of a cavalier disregard of rights. And I think the Commission, Parliament, the new Act, and coroners can take a lot of the credit for that. The default situation tended to be in the past that I've said, look, I'm a pathologist, I have a task to do, this is the way I was trained to do it. Autopsy, which is another word for it, means to see for yourself. I can't do that unless you let me do it as I've been trained to do. That approach, I think, is starting to change, facing up to the pragmatic reality. Lurking in the background is the fact that, however, another bit of a problem is that there is a great international shortage of trained pathologists, particularly forensic pathologists. They're the ones who do the difficult cases and the homicides and that sort of thing, where things are a bit uncertain or it might be going to a criminal trial. It's an ongoing issue, and it feeds into that dilemma I was talking about earlier about whether we should have gone to a medical examiner system. It's encouraging also to see in the Select Committee report acceptance of a role, of a proposition that was put up, which we see working very well in Victoria, with the use of an initial non-invasive interim inspection of the body, including the use of MRI and CT and quick toxicology. That works well in what they call the Victorian Institute of Forensic Medicine in Melbourne, sitting alongside the Coroners Court, because all bodies in Victoria go in there and they are all scanned in a preliminary way, which means that there's an opportunity for a very informed discussion early on between the key players, police, pathologist and coroner. I hear anecdotally that the implementation of that in Victoria has resulted in a substantial reduction in the number of full post-mortem examinations with an equivalent faster turnaround and less stress and strain on everybody. It remains to be seen how that will all pan out in New Zealand, and then the implications of that, if there were to then be a significant fall in the number of full post-mortem examinations, and you recall what I said about the pathologist's fears in that area early on. But there is new stuff coming up, scientific stuff coming up all the time, greatly enhanced MRI and CT facilities, much more rapid drug screening, using sweat and that sort of thing, so that you don't have the same delays we've had in the past. In addition to the forensic pathologists in New Zealand, we have a very loyal group of about 30 other anatomical pathologists, and we've got several in Hamilton who do a sterling job. The reality is that postmortems now are largely a coronial function. There used to be perhaps up to 50% of deaths had a postmortem, what used to call a postmortem examination, and it was an integral part of the training of young doctors, and it had its benefits. That's dropped right away. You hardly ever see a hospital postmortem, and it would only be perhaps if family were particularly concerned to know some specific detail that wasn't in the coronial area, and the hospital was willing to carry it out, that they would be done. So it's partly, I think, a resource issue, but also it's a mortuary availability facility issue and a pathologist available issue. The reality is much of what we now know in modern medicine, including particularly cardiac issues, is because of that research that was done back in the 50s and 60s with the large number of post-mortem examinations. So there's some pluses and minuses. I sense, I'm not sure I'm absolutely sure I'm right, but I sense that when I talked about those concerns that Maori expressed to me, that those, if I did the same trip again now, that those concerns are largely allayed, and there's a dawning awareness of the benefits of a post-mortem examination, and that it's not being done in an uncouth, insensitive way. In the paper I talk about, but I won't spend any time tonight on recommendations, just suffice to say that one of the things I'm pleased about is that now all our recommendations are posted on the internet via NZLE, available to anyone, and if there is a response, we publish that as well. So there's a growing body of information about what the coroners are up to. Not case reports, but those summary of the recommendations and responses. And we put out a thing called Recommendations Recap, which, as the Law Commission suggested was desirable, pulls together and identifies trends and patterns. And we've done reports in a number of areas, such as butane poisoning, huffing, suicide, forestry deaths, driveway run-over deaths, sudden infant death, to name but a few. I think the major underlying theme of the Law Commission report, and Mr Justice Baragwanath, who spoke to the Asia Pacific Coroners Conference we hosted in Auckland in 2010, as Pike River erupted in the middle of it, said the role of a coroner is a noble one. The role of the coroner is to speak truth to power. And sometimes that's not appreciated by the power part of it. The jurisdiction and the office has always been inquisitorial. And again, lawyers here will know what I mean by that. In the paper I expand upon it. The difference between an inquisitorial process and a criminal or civil adversarial process. Simply, basically, the classic statement is by Lord Lane in Sutherland and the Coroner. No parties, no indictment, no prosecution, no defence, no trial. Simply an attempt to establish the facts. That's always been the way an inquest has been run. The coronial system has been sometimes described as an, quote, inquisitorial cuckoo in an adversarial nest, unquote. The reality is that even for coroners, what operating in an inquisitorial way means is not well understood. There was a huge turnout of practitioners to some seminars Fletcher Pilditch and I ran last month for the New Zealand Law Society, which made the point there is a real role for lawyers in this jurisdiction, not only as coroners, but also as counsel assisting and assisting with helping interested parties. Judge Posner, who some of you will know of in a book called Reflections on Judging, and the quote, the citing is in there, talks about the inquisitorial system and its merits, and quickly says, in an interesting comment, I think, that in America, quote, whatever the merits of such a system, it's not about to be adopted in the United States, although pockets already exist here, and adds that what it would need is with the judge, the coroner being the main player and not the lawyers. The system requires a higher quality judiciary than the adversarial system because of the judge's role in an inquisitorial system. So ultimately, the coroner who decides what the issues are, there hasn't been a lot of High Court ruling in New Zealand that's got its up and down sides. The upside, I suggest, that is that we're getting it about right. The downside is that we don't actually have the benefit of High Court authority to give us a steer in some of the controversial areas. We've had a couple of cases, Carroll and the Coroners Court, where Madam Justice Wynne-Kelman spelt out guidelines about adverse comments, and also Justice Fotter guidance on publication of name of witnesses in Gravett in the Coroners Court. We've got the Kahui twins inquest, you might recall, where Coroner Gary Evans fearlessly strode into the mire of that after a quick acquittal in the criminal trial, leaving people saying, well, what did happen? And that demonstrates very much the different approach of the coroner's inquisitorial approach. What happened, why and how, as opposed to the adversarial criminal one, has guilt been proved beyond reasonable doubt. We don't have the authority the Australians have about the vexed area of the weight to be given to cultural and spiritual concerns. In England, they're starting to stumble into it. Interesting enough, not as with here or Australia with the indigenous people, but in England with the Jewish population. Of course, in Jewish law, it is abhorrent, the concept of a post-mortem examination, desecration of the body, and there is a need for a quick burial, as there is in the Muslim culture. A quick peek into the future before I wind up. The theme of the coronial jurisdiction is evolution. It's been going on for over 8 centuries, and I'm sure it will continue. Some interesting things I see on the horizon is we see in the English jurisprudence much more emphasis being made on the European Rights Declaration of the right to life, which is in our Bill of Rights. And the commensurate side of that is if there is a right to life, there is a right to know, particularly when the state is involved and a death occurs, what happened and why, for some sort of holding to account. That's not come into our jurisprudence yet. I suspect it may yet, although of course there's the difference between, as it were, an entrenched Bill of Rights and the New Zealand concept, of course, that the particular statute, i.e. the Coroners Act, overrides generally the principles of the, such as the right to life. Then there's the issue of the the skill shortage in pathology ranks. And I won't go into it, it's in the paper, but in England they're facing up to major problems. And there's talk about the service being fragile and corrective measures need to be taken now. To some extent that does reflect the New Zealand situation. We've been pretty well served by the dedicated men and women who've carried out coronial pathology in the past. And some new people are coming on, but the reality is the service is hard pressed in some areas and is vulnerable, like many in the medical profession, of an ageing workforce. Finding experienced anatomical pathologists prepared to work in the area is becoming harder and harder. They're a very precious and scarce resource. We don't produce enough homegrown talent, and if it were not for our ability to attract foreign-trained forensic pathologists, particularly American-trained, into Auckland, I think our system might have been in trouble some years ago. Mass fatalities, a matter of when, not if. I think we can be proud of the coronial response to the challenges posed by the Christchurch earthquakes, the flexibility we had with NIO performing the back office function, and a small group of coroners, including Peter Ryan, being rotated as embedded coroners out at Burnham Military Camp, meant we were able to play a small but vital part in concert with the other agencies to provide expeditious resolution of identification issues and early release of bodies with one reliable source of information. Also, quickly move to convene inquest for that distressing but fortunately small group of missing, presumed dead people of whom not a trace could be found. Our response there showed the benefit of some planning we had actually done, ironically, in early 2010, following my observing what they were doing in London on planning for the Olympics, plus the ability to learn from the Victorian bushfires, and also the experience of Pike River, which, although it was to some extent a sort of dry run, because eventually the coroner wasn't needed in terms of recovery of bodies, the networks and linkages that were built up were invaluable, and it all paid off when Christchurch happened. I could talk, and it would warrant a lecture on its own, about suicide, something that I've become very interested in. I talk about a gentle opening up of a discussion into what has been a rather taboo topic. I think the whole approach is changing. I think there's a greater willingness for people to want to know more about what's going on, this distressing familiar. 10 times a week, give or take, someone commits suicide, and it still baffles me as much today as it did when I first became a coroner. There's a theory that if you talk about it at all, it's risky because it might encourages others to take it. I don't buy into that. But that, and then the linkage with, if we go anywhere with euthanasia or assisted suicide, is an area that's going to be really very interesting. As I say, I could talk about that for a whole lecture, but I won't. Interagency cooperation has been something I've been pleased about. 3 quick areas: what's called molecular autopsies, the concept of cardiac inherited disease, the young person or the baby who dies unexpectedly, or the apparent drowning that really doesn't seem right. Young people dying suddenly on the rugby field. Huge amount of work being done, and we've done a lot with the cardiac inherited disease groups under Dr. John Skinner up at Starship to get work underway there to sometimes provide a solution for what is essentially a genetic link to things like what's called LQT syndrome or Brugada, one of about 100 different things, to do with the electrical activity in the cardiac area through a genetic mutation not working properly. Sudden infant death, something that distressed me, was a young coroner with young children. The number of these has dropped dramatically through a lot of good work being done. I'm proud of what we set up with getting a pilot program going with the assistance of Health Research Council funding under Professor Ed Mitchell, to have what we called health-trained investigators go out to visit the site of a sudden infant death, talk with the parents, gather data of a type the police were really not geared up to produce. And there'll be some very interesting research papers will start to come out this year and next on that. There's also, we've set up with the Ministry of Health a suicide postvention project. A lot of mystery and misunderstanding, rumour about suicides. We set up a system whereby in virtually real time, NIO would send to a trusted source within the Ministry of Health information about a suicide. That information can then go immediately to the key people who could be involved, such as the Ministry of Education Trauma Intervention Team or CASA, to turn up at the school before the headmaster even knew he'd had a suicide, and said, "You had a suicide in your school community, university community last night. You don't know about it. We're here to help." And that, again, is an example of useful interagency cooperation. And I think that for the future, that is where the coronial system probably needs to go. So, to wind up, have we measured up to the vision of the Law Commission? Bearing in mind, they said the community is the ever-present client of the coronial system. The Ontario Coroner's motto, to speak for the dead, to protect the living, that's obviously for others to say. But what's been interesting is that pattern I talked about, it all came from England, we followed England, suddenly that's all changed. England looks to us now. They are rather awestruck at what we did, even though we went down the Big Bang approach. They are wistfully envious of what we have achieved through a combination of things. They now have a chief coroner. I've spent quite a bit of time with him. He was particularly interested in asking me how we worked our system and learning from us. And that was a nice feeling that the apron strings, as it were, have been reversed. The last thing I just want to observe is it's interesting to note when we started out in 2007, we had 4 women coroners. We now have 7 out of the 16, and the chief coroner is a woman. In an interview in Law Talk, the Law Society publication in the early days, I noted that the coroner's job seemed to be a job that warranted attention from women lawyers, and it's good to see how things have panned out. So I think, from my perspective, the public profile of coroners has developed. Media interest is high, and it was a major part of my job. Speaking to groups here and overseas, and clearing up things with media. In conclusion, when I look back and reflect on not just the last 8 years, but also my whole time since 1978, the one thing I think we have is we owe the Law Commission a huge debt. Thank you for the opportunity to give what is effectively my first ever report to the public of New Zealand, which, as I pointed out, was something the Commission envisaged, never came into legislation, but here it is. And thank you to Harkness Henry for giving me the opportunity. Thank you.
We have some time for questions, so any questions for the judge?
Protect the lives of its citizens. One could argue that since the advent of Rogernomics, the state has done nothing but actively retreat from the role of protecting the lives of its citizens. So to what extent do you think that comment is fair in terms of the coronial system?
I think it's fair in terms of the coronial system, whether it's fairly reflects the reality of the state in 2015 is for others to say. But the fact that we have an independent, judicially based coronial system with the power to actually fearlessly go into areas, find out what happened, as Justice Baragwanath puts it, to speak truth to power, I see that as fundamental. That it is, at the end of the day, it's the state that actually sets up the coronial system. And some of that jurisprudence I was telling you about, it is of the type where the European Court will actually give the British government a rap over the knuckles or plaudits, and they will say there needs to be set up a truly independent of the state investigative power. And by and large, if there is a proper coroner's inquest, that meets that application. If the coronial inquest goes off half-cocked or is misconceived or its powers are constrained, then that's another matter. So as to the general proposition, does the state fully recognise now its right to protect the lives of others? I don't know, but is the coronial function achieving that? I think it is, but it's for others to say. Yes. A lot of it goes on behind the scenes. And one of the roles of a chief coroner is to actually stand up for the coroners, and where there's a perception that anyone, be it state or powerful organisation or district health board, is trying to railroad the coroner or divert attention away, or even police sometimes. In a police-related death, the chief coroner's role, as I saw it, and I did have a role to play, and that was to quietly step in, and usually all it needed was a quiet word of sort of the lines of, hey, listen, back off, we have our job to do, just let us do it. Yes? I always remember, my wife Sue here will remember, I was having a coffee down with the university people in Otago a few years ago, and Donna Buckingham came up to me and to my wife for amusement said, "I've been lusting after you," and then quickly explained that she was desperate to get a system going of coronial reports on NZ Lee. And that was the catalyst for what we did. Now, I mean, I've now got the experience of working as I do in ACC appeals. When I make a finding, like today, send it through to Wellington, it's published and it will be in full on NZ Lee, the full thing, subject to any suppression, sometimes literally within days. I'd like to see the coronial system get to that stage. It's resource intensive. If it were not for NZ Lee, I think we would struggle with our present resourcing to do that. But it seems to me that what we do is worthwhile, then we need to do better than just the ones that had a recommendation. The public of New Zealand is entitled to know what the public courts are doing. So, yeah, that's something I'd like to see happen, but, and I'm not sure, I think there are slow moves towards that, but there's a few fish hooks, like how do you deal with the stuff that shouldn't be into it? Because a lot of a coroner's report will contain stuff which really is nobody else's business, and the actual exercise of, in effect, redacting it without reducing it to a sort of a meaningless garbage, like an Official Information Act response from a department that really doesn't want to tell you anything, is counterproductive. But it's an area I think we should go. I think there is a need to take that further. Yes. I don't know, you'd have to ask my wife that. It's like a lot of judges. I mean, we've got judges, family court judges here and criminal court judges here today. It's the same issue for them. You deal with some stuff in your day-to-day job that's pretty distressing, but it's no good you starting to blubber or sort of break up about it. You've got a job to do, and you owe it to the people who are dealing with to stay objective and deal calmly with it, and not let the emotion get to you. And I know that's not really the answer. The question is then, well, okay, having done that, then does it have an effect on you afterwards? Yes. And I do take my frustrations out on the computer sometimes, but and the back's gone, so yeah. I don't think there's a strong causative link though.
Any further questions?
When you're dealing with recommendations, for instance, with forestry or the farm ATVs, how do you deal with that in terms of with the coroners? Do you everyone gets round together and discusses it before a recommendation goes out and the press gets hold of it?
It's interesting. One of the practice notes, and I didn't do many practice notes, but one of the practice notes that I did, which is on our website, was this concept with the Law Commission was very interested of if you were going to make recommendations, not just do it on one case with the criticism that the coroner could extrapolate from one, say, ATV deaths, principles that would apply wide. Why not group a number of them so the more you have, the more chance of themes coming through are there. And we experimented with that, as you may know, with a number of ATV deaths. That was Brad Shortland did that. A number of cycling deaths. Gordon Martinga did that. And a number of others. The jury's still out on that. The upside is the more cases you have, the more likely you are to get sound recommendations that are really based in reality and focused. The downside is that it can add to the delay immeasurably, because to some extent getting it all done can only go at the pace of the slowest case, so that for the new chief to say where she wants to go with that, we got some good reports out of the cycling joint inquests, out of the ATV deaths, out of the butane deaths, and harking back to Joan's question about some resistance, there is, I sense, some resistance in some circles to coroners, as it were, getting too big for their boots and sort of, as it were, holding mini royal commissions. Traditionally, the coroner has always focused on a death and the lessons to be learned from it. And so it remains to be seen where that all goes.
Okay, I'll hand over to Joan for some concluding words.
Thank you, Judge MacLean. It's, for those of you that don't know me, I'm Joan Forrett. I'm one of the partners at Harkness Henry, and I'd like to thank you so much for your willingness to come and give this lecture. You agreed to speak and were undaunted by the preparation required for this paper, which is to be published in the Waikato Law Review as this 24th Harkness Henry lecture. Just before I go any further, on behalf of the partners of Harkness Henry, I'd like to acknowledge and thank those of you who have come tonight, including those of you who have come with your germs and ailments. It is appreciated, and I mean that sincerely, but we do have a lot of apologies. There are too many for me to read out. I will mention that both Lyndon Earle and Matthew Peplow, who are partners at Harkness Henry, have been unable to come tonight, and Judges Milroy and Coxhead have also given their apologies. We have been beset by people who seem to have either have the lurgy themselves or have family members that are suffering. So those of you that are here are the strong ones. Thank you for attending Mayor Julie Hardacre, a former classmate of mine from law school. Your Honours, members of the judiciary who have come, and particularly Judge Menzies, who has gone over to the dark side, but will always remain one of welcome as part of Harkness Henry's whānau. Thank you, Dean Wayne Rumbles, and congratulations on your appointment, and also to the staff of the law school. This te piringa is very much part of Harkness Henry as a firm. 6 of the 8 partners at Harkness Henry now have law degrees or other qualifications, Dr. Scotta, from te piringa, and our solicitors, vast majority of them come from this law school. I'd also welcome Professors Barton and Wilson. Thank you for your loyalty and support of this lecture. The Deputy Vice-Chancellor's here, Alistair Jones. Thank you, Alistair. And thanks also to the Harkness Henry staff, the university staff and students who've come. In particular, I'd like to thank my personal associate, Lee Van Houten. She does a huge amount of work every year preparing and organising for this event, and she's assisted by Deanna Malaseva from the university. Between the two of them, they organise half of Hamilton, so thank you, ladies. Your Honour, your talk is described as a reflection on your role, and it was a role that saw significant changes. There was clearly a need for education and training, and a recognition of a specialist role within our legal system. You have given us an insight into a part of the legal system which most of us have very little practical knowledge about, and yet it is so significant to many families with bereaved friends and relatives, and it's also so significant to try and reduce the incidence of accidents and so forth causing death. The preventative role is so significant in our society. There has been a lot of interest in your talk tonight. I'm aware that you have today been interviewed on Radio New Zealand by Jesse Mulligan, and that is already available for downloading on as a podcast. And I think that there will be a continuing public conversation related to the reflections that you've shared with us tonight, and I thank you very much.